Hello, this is Gary Berger of Berger Law. I am coming to you live from my office today. I have joining me today Tyler Thompson of my office. Hi, Tyler.
Good afternoon.
We are appropriately, how far apart are we?
6 feet.
8 feet, 10 feet. Let's keep it that way, no offense. So very excited to have you today. Tyler is a great lawyer who works with me at the firm, and I thought that we would change it up a little bit and have him involved as well. Although it's a little bit hard to do like a camera with him, but I think everybody can hear him. So one of the things, so Tyler, tell me about what's been going on the last week. Tell me something people might be interested in hearing about.
Sure. We've been, I guess what people would be interested in hearing about is the part of a lawsuit that happens before a lawsuit. A lot of times you're talking to an insurance company beforehand, and sometimes you can get a better result doing that, and often you can get a quicker result doing that. And so we've been doing a lot of communication with insurance companies before a lawsuit even gets filed, and people don't always know that you can use an attorney for that too.
What question? What is it? So the question is, do we call that the claim stage of a case?
Yeah.
What's the most important way or most important thing you can do as a lawyer for our clients in the claim stage of a case before a lawsuit's filed?
I think what we can do at that point in time is help them to make sure that they're in the process of getting whatever medical care they might need, and making sure that when they do communicate with the insurance company, they're doing so in a way that's to their advantage and not just to the insurance company's advantage.
Right.
So that when they speak to the adjuster, or when we speak to the adjuster on their behalf, we're often able to communicate things in a way that can help their case even before the suit's filed.
That is true. That is great. It's been a busy week here at the firm. Since last week, we've been doing a lot. I expect questions about some certain things. We've been in the news a little bit. But let me go to some questions that I was getting this week. Right away was, can you, Tyler, the question Tyler and I were just talking about, so last week, Tyler, I know you watched the show. I talked about waivers last week, and then I did a segment on Channel 2 about waivers with COVID. So how do waivers and public school employees, and liability, how does that interact?
Well, the community would be the buzzword there, I think. Public schools, public entities, fire departments, police departments, other government businesses that you might work with have sovereign immunity under certain circumstances, or businesses might have immunity because of a waiver that you signed. So you want to make sure that before you sign something, that you take a look at it just to see what it is that you might be waiving under circumstances.
Right. So we got some questions since last week about waivers and COVID. So the city of Hazelwood and others are putting COVID as part of their waiver. Now, remember that schools, they may have some immunity, but they don't have immunity for if their employees are not using their discretion, if they're following the rules. They don't have immunity if it's an automobile crash. They don't have immunity if it's a premises liability or property damage case or a dangerous property case, and they don't have immunity if they buy insurance for it. And they have a program called MUSIC, the Mutual Unified School Insurance Corporation, that they work through. So they don't have immunity for that. I see some questions coming up already, so I'm just going to go straight to the questions. And so Davey asked me, is it true that you're not allowed to carry a cell phone into court? If so, why? Is this just to prevent distractions, or is there another reason? So let me go with that one. Let me take that one, Tyler. The answer is most people, like regular people, aren't allowed to carry a cell phone in a court. but lawyers can. I have to show my bar card sometimes to bring it in so I can text and do emails while I'm sitting in court and waiting. But most people cannot. They do that because you don't want to improperly record court activities. So there are sometimes in trials, there's evidence that they decide should not go to the jury, or there are hearings outside of the jury in a civil case. And they don't want someone to take that, record it, put it on the internet, and let a juror see that. People in criminal cases are afforded innocent until proven guilty. Or there's things called Alford pleas where they plead guilty, but they don't really plead guilty. So you don't want to have people recording that, doing things with that inappropriately. I know that, although I think most jurors get to keep their phones with them during jury duty, as I recall.
Yeah.
So jurors do, but regular people can't, right? Most of the time, or what do you think?
It depends. City and county, you're not going to be able to bring it in.
There you go.
Smaller courthouses.
Jefferson County, you can't.
Jefferson County, you cannot.
But if you're on jury duty, you can, because we have one of the instructions in. It's kind of funny. One of the instructions in our for jury, it's called 2.01. They say you're not allowed to look up anything. And I just happened to pull this literally out of my cabinet. And you want to know how long ago they wrote this? They talk about MySpace in here in the 2.01. So they say you're not allowed to do your own research, do your own studying, because one of the rules about trials is they want to have the evidence that a jury considers the evidence that they hear on the witness stand or by a document, because there are specific rules about hearsay. And they don't want people getting unsubstantiated evidence outside of court and relying on it as true. We have a huge problem with that on Facebook and other social media, and especially in our political world. People posting articles and they're not true. And did you scope that? What's Snope? No, what
Snopes.
Snopes. Did you Snope that? Thank you. Anyway, so that's anything else on phones in the courthouse that I missed?
No, I guess I'd just say when in doubt, maybe leave it in your car.
When in doubt, leave it out.
Yeah, or talk to the bailiff.
Right. So they'll tell you when you go through the metal detector, they'll make you go back to your car, or they'll do some other things. So that's the reasoning behind that. Brennan writes, I love the guest speaker idea. Is it true? So I made Tyler do this today. We're both working in the office today. We've gone back. We each work about 2 days a week in the office. We stagger shifts. We stay in our offices. Tyler had a meeting with me. I asked him to come in this. We're trying to stay separated, but we also know we're both socially distancing, but we're careful about that. We have our firm rules. Is it true that if I put $1 in your pocket that I can tell you anything and it remains confidential? Tyler, is that true? I have $1. I did not have this as a prop. But here's $1. So you don't touch that because I touched it. Is that true?
I believe that's true for the purpose of seeking legal counsel.
There you go.
But you can't just...
Not a random person.
Not everything and everything, but yeah, if you're seeking legal counsel and your advice, you are then retained as an attorney.
And I'll do you one... That's very true. I'll do you one better, Brennan. When I have clients who call me and I haven't taken their case yet, even consulting with a lawyer whom you have not paid any money to in a matter is attorney-client privilege. So I'll have people call me up in a case that I'm considering taking or they're requesting that I take, and I say, listen, we have an attorney-client privilege even if you don't pay me. So that, and even if you decide not to hire me, our communication is protected. Sometimes you can, I've had instances where we have a deposition going on today, but I don't want to get into that, but we have situations sometimes where witnesses, we can get a lawyer for a witness for free, and they don't have to pay him, and there is an attorney-client privilege. So the idea in the ethics rules is basically, in a nutshell, is if the client has a reasonable expectation of client confidentiality, they are afforded that confidentiality. Kira asks me, how do you feel about children returning to school in the fall? I've been talking a little bit. I have kids who are literally doing this right now, but I'll let Tyler talk about that a little bit. I don't want to steal all the thunder.
Sure. I have young kids. It's something everyone is debating. Our hope is that schools reopen. Our older is going to be in preschool, so it's sort of a different issue that we're dealing with than if you have kids that are a bit older. Our hope is that they return to school and that the schools do what they need to do in order to keep people as safe as possible. But I think we're fortunate with respect to COVID that it doesn't seem to be, to this point in time, affecting kids as significantly as it's affecting others. And so the hope is that will continue and our kids will be able to go back to school and be healthy.
Yeah, well said. I have one kid going to college, two kids going back to grade school and high school, and they have different. You can for the high school you can opt in for online learning only. My two daughters don't want to do that. And then it's unclear to me. And in fact, the governor asked them to extend the decision about into next week about whether they're going to go back full time or a staggered part time like I'm doing right now at the firm, where everybody goes 2 or 3 days a week. Rockwood doesn't have an option for full-time school. It's only staggered to try to promote social distancing and such. Interestingly, the school that my son is going to college in, they have a great, nice campus in New Orleans. They're building like 16 new buildings with aluminum frames and just kind of warehouse buildings in these quad areas to try to give more space for socially distanced learning, for eating and that kind of stuff. So everybody's doing stuff. It's a little bit haphazard because of the lack of central leadership, in my view, either from the governor's office or the federal government. It'd be a lot easier if someone came in, because the problem is each school district has to figure it out on their own, and they're not doctors, they're not experts, so they got to go consult with people they know, and then go to the St. Louis County is putting out recommendations, but it's a little haphazard in terms of the authority people are using. So there you go. That's what I think. I don't know. It's tough. I think my kids are going to go back to school. I think they're going to do it staggered shifts. I don't know. I mean, it's school. Different kids are different. Some kids really benefit from the classroom. Some people really need the socialization. But each kid's different. I got one of my kids. He would be great in online learning. Some of my other kids would really benefit from having a teacher there to work through it, because people learn different ways. People learn different subjects different ways too. Rodney asks me, do you think MySpace will come back? Can old social media accounts like MySpace be used in evidence against you? I think you put all your money in MySpace right now, Rodney, number one. Number two is I think your newest pictures with your hair on Facebook are about, you can't get any worse than that. So I don't think your MySpace can be used against you that much. Adam asks, and I can see that you can't, if you can, Tyler. All right, going down to Adam's question. Is the judgment you won in the case against Pam Hupp? Wow, congratulations on yet another meaningful victory. Well, we got all kinds of questions coming through here. I'm going to try to catch up. So what I try to do is I try to stick to the questions and answer. I mean, we can talk about ourselves a lot, and we do a little bit in the intro, but I'm trying to keep things moving. So I obtained a $3 million judgment on behalf of my client, Margaret Birch, on Friday. We went to court on Friday. It was very interesting. We had masks on. I put her on the stand. We were both wearing masks. These kind of masks, not these kinds of masks. We obtained a $3 million judgment against Pam Hupp. It was done to vindicate or to get some modicum of justice, although it could not assuage the grief and the sad story that Margaret told from the stand. This has been in the Post-Dispatch and a couple news outlets this story in the last week. Margaret took the stand and gave some of those most powerful evidence, powerful testimony I've ever heard about how the tragedy of how her son, who had the mental capacity of a child, because of a brain injury at a car wreck, how he was lured into Pam Hupp's scheme and was murdered, and then lies told about him and why he was there, and we filed a lawsuit. We went and got a hearing, got a $3 million judgment on Friday, as I said. Louis Gumpenberger, Margaret's son, who was killed, would every time he got a paycheck, she told this story from the stand. She's shaken, the podium's shaken. I didn't know whether to, it's a default hearing. Do you ever hear testimony like that?
Not like that.
No, and the judge said, I didn't know what to do, and the judge said, let her speak. And then afterwards he said, you've never had a chance to tell your story. Thanks for telling your story. And the judge was overly compassionate, and just what a wonderful man to give her that opportunity. She said every time he got a paycheck, he'd take his son to Walmart and buy him a toy, and his son can't do that, and it's affecting the child. And when these people forget about the tragedy of the victims, and especially with someone as crazy as Pam Hupp's, such a sensationalized story. Sometimes the news doesn't take time for the victims like they should. Margaret spoke eloquently and passionately about her son and the impact it had on them, and the anger that she has and the remorse that she has. It was very moving, tremendously moving. I was honored to represent her, honored to help her get this judgment. So that was great. It was a great result. Thank you on the congratulations. I have on my wall here our oath to be a lawyer, and it says that we should do pro bono and should help the oppressed. Zealous representation of everyone, including those who are oppressed or those who don't have the power to speak for themselves. So I was happy to do that. There's another question about Birch versus Hupp. In cases like Birch v. Hupp, are there additional legal penalties if the defendant doesn't pay the money? I understand there are things like wage garnishments, but is it criminal not to follow through with it? No, it is not. So the way Georgia was colonized was from people in debtors' prisons back in the 1600s. So we don't put people in jail anymore for owing civil money. So you can't. There's no way to criminally punish someone from owing money. In fact, you can declare bankruptcy, which is one of the reasons why we had claims for fraud and misrepresentation on intentional assault. So it could not be discharged in bankruptcy, Tyler. And you can garnish them. Now, I don't know if Ms. Hupp has any money, and I know the state, takes people's money to pay for incarceration. But one of what Margaret Birch told the judge was, she said, I don't want Pam Hupp to ever profit from the murder of my son, and so we're getting this judgment so that doesn't happen. So if she would ever do that, we'd be in line ahead of her in terms of getting money. So we'll serve a garnishment on it.
Yeah, going forward, she would potentially have the opportunity to recover future assets, correct?
Right. Yeah. Any thoughts on that case from an outsider? I mean, not that you're an outsider, but you weren't really involved in that case.
No, it was a great result. It's unfortunate that if Margaret's going to derive some kind of benefit, it's possibly in the future. But I think in a case like that, telling her story was the biggest thing, and the judge affording her the opportunity was very kind. And was it who was it? Was it Judge House? Fagris. Yeah, he's a good man.
Good man, relatively new. It was not Judge House's retirement. We had Judge Pelican. He had to recuse himself because he was involved in the underlying litigation. All right, here's a question for you, Tyler. Are there official dress codes? We can talk more about the Hupp case. I've done some interviews about it. I'm happy to talk about it. Kira, I was trying to decide whether I should wear a bow tie today, and I decided not to. I decided this tie went better with the outfit, but I can't be the same all the time. You got to change it up. Tyler, that's a question we have. Tyler, are there official dress codes in court for lawyers, defendants, jury, etc.? On TV and movies, everyone dresses up, but is that a requirement?
For attorneys, you have to wear a suit. That would be the dress code. For defendants, I would recommend a suit. If you are going to stand in front of a judge who is going to have some say about whether or not you go to prison or some amount of money that you might wear, I would at least make an effort to look nice, or at least show that you made an effort. Not everyone owns a suit. I'm not saying you should go out and spend a few $100s to buy a suit if you don't already have one, but make it clear to the judge that you have made an effort to look nice and presentable in front of the court.
What about your client in a civil case?
My client in a civil case, I usually recommend that they wear something comfortable and presentable, but that they not wear a suit to distinguish them from attorneys. I prefer my client not to be wearing a suit and tie.
I say nice pants and a nice shirt. Right. I do not, for my clients, I do not have them wear, their Sunday best or a suit, just because I want them to look normal, so that a jury identifies with them as normal people. And also, you don't want to, put on all your jewelry and all your stuff and look in a courtroom not how you are in everyday life. That would not be. I want them to be real as they can be, and connect on that level. What about juries? Jurors? What's the dress code for jurors?
That, as far as I can tell, there really isn't one aside from what the judge's expectations may not be. But I've seen jurors in pajama pants and sweatshirts. I've seen jurors wear ties before. That again, I think, is just something that you're comfortable with and you feel comfortable with in public, and recognize that you're going to be sitting in a room with a fair number of people for a fairly lengthy period of time. So I might recommend comfortable shoes also.
All right, good. I agree. Adam asks us, I did wonder about lawyer ads. They seem to always have a disclaimer saying don't choose a lawyer based only on advertisements. I'm assuming the disclaimer is required by law, but where does that requirement come from?
My understanding was that it was previously against the ethics rules for attorneys to advertise. They changed that, I think in the early 90s, allowing for commercial advertisements for attorneys. But you are correct that the disclaimer is something that is required for them to state, the same way that they've passed the law now that politicians, you all see at the end of the commercial, if it's from their political campaign, they state, I'm so-and-so and I approve this message. It's something similar to that. It's a legal requirement that they let you know an attorney is an important choice, because it is an important choice. And I think advertising on television works very well for some people, but I would not recommend choosing your attorney based solely on ads.
Right. So so I picked it up, my rule book. I'm sitting in my office. So there's a whole, if that's Ethics Rule 7.2, that requires in that it says you have to have it conspicuous. So 7.2F, advertisements or communications shall contain the following conspicuous disclosure. The choice of a lawyer is an important decision and should not be based solely upon advertisements. So that's why you have to do it. In Missouri, not in any other state do they require you to do that. Missouri has very strict in that regard. Now, there are other states that have different constraints, but Missouri, for some reason, is one of the leaders in that. You also have to keep advertisements for 2 years. There's other restrictions. There's also restrictions on solicitation with prospective clients. So if you ever get a speeding ticket or something, and then you get criminal defense lawyers sending you letters or that kind of stuff, you've never gotten a speeding ticket. But anyway, so you're not allowed to you can't solicit a case in person. The only time you can do it is you can solicit a case in writing with 30 days after an incident has happened, and there are specific requirements in that under Ethics Rule 7.3. Do you remember the movie The Verdict?
I do. Great movie.
You remember the first scene?
Yes, he is at a funeral, and he's playing like he knew the guy that passed away and had no idea who it was.
I was trying to get the death case.
Yeah, I was trying to get the wrongful death case.
So he violates Ethics Rule 7.3 because he's trying to solicit someone he knows might have a claim, and he is violating that ethics rule. And that's part of the movie. He goes from the pit, that's his ascendancy during the movie. He goes from committing an ethics violation and being an ambulance chaser or whatnot, or a death case chaser, to doing the right thing and getting a great result from a client in a trial.
Yeah. Although it's a great movie, it's funny, both the defense attorney and the plaintiff's attorney that do something that would be sanctionable.
Right. Right.
Pretty seriously sanctionable.
Right.
So I wouldn't use it for legal advice, but it's a terrific film. Paul Newman's great in it.
These questions are great today. I got my rule book twice. I always have my rule book by me. So let me go to the next questions. Then the requirement comes from that. There's a dispute. So, yeah, and Tyler said about where the rule comes from. Dress code, no bow ties. In a case like Pam Hupp, if the guilty person doesn't have the money income to pay such a large judgment, what happens to any future wages they earn? Does everything go towards the judgment amount, or can the court legally only take a percentage of wages? Secondly, does this also apply to all types of judgments, such as injury or other fault cases, or was this a special type of case as they may be allowed to do more? I'm going to get in my rule book again. There are rules on garnishments. So let me lead with this one, and then you add anything. Is that okay?
Absolutely.
All right. So you can garnish people. So you can serve a garnishment. I got in the news this year, when I garnished the state of Missouri for $113 million because they did not post a bond in this big case that we won, where I represent these corrections officers. So they didn't post a bond. And did you know that I garnished the state for $113 million?
I didn't.
It hit the fan. It hit the fan, and they filed a motion to quash with the Court of Appeals, and they won. And I still think I'm right, but they said they have immunity from this because there's an old case where someone won a second injury fund decision, and they went and garnished, and the state wouldn't pay it, and they went and garnished it, and they said they have some immunity to that action. So it's an interesting issue about whether the state has immunity from executions. But normal people, unless you're a sovereign, a government, you don't have that immunity. So if I get a judgment against someone, I can go collect against their bank account. I can go seize real property or land that they have and force a sheriff's sale and take the funds from that. Or I can sue their employer for wages, and there are garnishment rules for wages. People do that in child support. If they don't pay their child support, people should pay their child support. So you go garnish the employer, and then the employer has to take that out of the wages that they give them. But you don't starve people. So there are rules about garnishment, only being able to take like a third or 50% of the wages after taxes. And then there's different rules for child support versus a debt, and so there's all these rules about a propriety of garnishment. So if someone doesn't have the money to pay the future wages they earn, you garnish them. Everything doesn't go to the judgment amount, just a percentage. So that answers those questions. And it happens for all kinds of judgments. It doesn't matter the type of case or the underlying case. If it's reduced to a judgment and cannot be collaterally attacked or is beyond that time, it's a judgment. It doesn't matter whether the person thinks it was bogus or not. Although you can challenge a default judgment for a year, and then we don't need to get into too much of the details on this. anything else on that?
No, I think you covered.
All right. The next question is a great question. I think it's for you, because the question is, are you still cutting your own hair?
I am still cutting my own hair. I've been doing it since college.
Was that question for Tyler? I don't know. I'm going to go back. Hold on. Okay. I think we had a brief power outage, a brief Wi-Fi outage on this on this live show. So I apologize to those who posted those great questions, and then I may have either clicked someone or we lost something here. Should I blame it on the internet?
I blame it on the internet.
All right. So the next question that we had was, are you cutting your own hair? He is not. Yes, I am cutting my own hair. I call it the number 6, but I cut my hair so I'm getting pictures taken of my family pictures my wife set up on Sunday. And so about 2 weeks ago, I cut my own hair again, and I did this big divot over here where you can see my scalp, and my wife is like, I think she hid the razor. I'm not allowed to cut my hair until after our pictures.
I can just fix that with Photoshop.
Yes, I guess we can do that. We're going to have a good photographer to do that. So it looks like I lost a bunch of the questions I had, but I remember them. So another question they had was, in a case like this, what's the rule on challenging default judgments? Tyler, do you remember?
You file a motion to set aside a default. You have a year to do it, although I would do it as soon as possible, because some judges will look at how long you waited to contest it in deciding whether or not to grant your motion. And I believe it's completely within the trial court's discretion as to whether or not they want to set it aside. So sooner would be better. You have a year, but I'd do it ahead of that.
So one of the great things on this that we did in this case was the client, Miss Birch, had come to us after the statute of limitations had run to pursue this case. So there's some interesting case law that we cited in our petition, and which the court found that, statute of limitations is an affirmative defense, so you can still file a claim. The other thing is that if there's a case law that if you committed murder and or you're hiding the nature of the crime and hiding what happened, that you can equitably stop the defendant from asserting that as a defense, so you can still maintain your case. And so, interestingly, the court made specific findings about that in our case. Were you aware of that law?
I didn't know that. No.
Yeah, and it's a case with the murder and that judge. A Supreme Court did the opinion. It's about a 2-year-old case, so we asserted that in the case. I think we don't have any more comments or any questions. I think I lost the other feed, and whatever I did or whatever happened. Tyler, in terms of collecting and garnishing and executing on a judgment, is that something that's typically successful if you hold a judgment in a case? Or what's your experience?
My experience has been that largely depends on the defendant and your willingness to really stay after it. Some defendants have, they have a lot of assets. They have a lot of very easily located assets, and so you're going to have better luck in those cases. And I think, the cliche is you can't get blood out of a stone, and that's a cliche for a reason, because there are defendants that we call them basically judgment proof, and that they don't have any assets of any kind. And so, unfortunately, in those cases, your judgment is going to be about worth what the piece of paper is printed on is worth. But you do have the opportunity to attempt to collect if they might walk into a 7-Eleven tomorrow and buy a winning lottery ticket, and then you can be first in line. But that's largely dependent on the defendant or the insurance that you're dealing with.
Here's a question that came up. If in that Hupp Birch case, if Hupp doesn't come up with the money, how do you get paid for your work? If she doesn't come up with the money, how do we get paid?
We don't get paid.
We don't get paid.
That's why it's pro bono.
We don't get paid. It may not be pro bono, but it is so far. Here's another question that is on the list that came up. What is the penalty for abusing benefits like work comp or unemployment? For example, if someone fakes an injury or exaggerates it to get out of work. So let me go first on that one. So the unemployment, you will be found to have been discharged for misconduct relating to your work, so they deny your unemployment benefits. And similarly under work comp, if under work comp, if you make up your injury or something like that, the benefits are going to be denied. The employer is going to deny the claim, not pay the benefits. The work comp insurance companies vigorously defend these cases, even on really good straight up cases, and they will deny the benefits and won't pay benefits, and that can happen. Now, also interestingly, there's a penalty for employers who abuse the work comp system as well. So I have had 2 cases in the last 3 to 4 years where I had an investigator from the state of Missouri charge a defendant criminally for an employer criminally for failure to carry work comp insurance when they were supposed to, failing to comply with the law on reporting claims or paying for benefits. So there are criminal teeth for employers who thumb their nose at the work comp system. Similarly, if as a business I pay unemployment insurance, so if I don't pay, there are consequences for me not doing that as well. Let me throw this question to Tyler. Tyler, here's another question. If pedestrians always have the right of way, even if they are jaywalking or cut in the middle of traffic, are they still free from fault if they get struck by a vehicle?
I would say no, and I would not say pedestrians always have the right of way. If you are wearing dark clothing at 3 in the morning and jogging across Lindbergh or Olive or a busy road with a high speed limit, and you get hit by a car, it really depends on the circumstances of the individual collision itself. If it's a young child in a neighborhood that darts out into traffic, a jury is going to look at that a lot different than a grown adult doing the exact same thing. And so I would say it under those circumstances, it more depends about the individual case and the individual incident, what happened. I used to work for an insurance company, and we had a case we were defending, and it was almost exactly what I described. It was a woman on Hanley in the middle of the night wearing dark clothing, and she was hit by an automobile and severely injured, and the jury found her completely at fault for that because of where she was and that she wasn't looking out for traffic at the time. So it really depends on what a jury is going to think about the situation.
Right. It's a right-of-way issue. So sometimes the car has the right-of-way, sometimes the pedestrian has the right-of-way. If a car has a green light and the pedestrians cross it, the pedestrian can't cross through a red light, go in front of a car, and expect that car to stop. The car has the right-of-way under those circumstances. So we consult our rules of the road, Missouri's rules of the road, which I will show you here. I got another prop. Here's Illinois rules of the road. I always have the rules of the road at my fingertips because we use them in cases. I have the Missouri commercial rules of the road. I'm sitting by my bookshelf here, and it tells us what the rules are on right-of-way and failure yield and stuff, and so sometimes they do. But remember that a pedestrian doesn't have to be in a crosswalk. So the law says that if it's one sidewalk going to another sidewalk, they got the right-of-way. They can cross there if they have a green light or there's a four-way stop they can cross, because you do have to yield for that, or if it's a yield for pedestrian sign. However, I've had many cases where, and I have had these cases and where someone's crossing in the middle of a highway at night and they get hit. I turn that case down because that pedestrian, it wasn't the car's fault. It was the pedestrian's fault for not yielding the right of way to the car. I've tried these cases. I tried and lost a pedestrian crosswalk case in the city one time. Picking a jury in that I had a case with a car and a case with a bus, and sometimes I go in there saying, don't you think that because the car, because they're going so fast and you're trained to drive and you have a highest degree of care, shouldn't they be really, really careful? And jurors say, yeah, but then they say, but the pedestrian who doesn't have all that metal around them, or the bike rider that isn't protected, that they ought to be even more careful. So yeah, I've learned lessons in trying these cases. People's views towards bicyclists and pedestrians, don't think that they'll lean in favor of the pedestrian necessarily. That's what I found.
Yeah, I totally agree with that. People expect pedestrians to be aware of what's going on to at least some extent, and you're obviously not driving a vehicle down the road, and so there's a different level of awareness. But maybe don't check Facebook on your phone in the middle of the highway.
Ken Muskegon. Ken Muskegon is, if this is the same Ken Muskegon, Ken, you're one of my favorite people. There was a witness, and I'm going to just say this story. There's this witness at this trial that I did for the corrections officers who told an amazing story about how the state of Missouri instructed when they were trying to get data about how people were for timing of the pre and post shift activity, how they were cooking the books and instructing them to throw out long periods of time. And there was a witness who testified they were cooking the books. If it's the same person who's asking this question. And the question is, when do you think the state will judge a judgment for state pain and corrections officers? Ken, it is pending before the Missouri Supreme Court and has not been decided yet. So we're just waiting on that. Here's a question for you, Tyler. Tyler, what's your favorite part about working as a plaintiff firm versus a defense firm? Do you think your prior experiences benefit you and your clients?
I think my favorite part about it...
Did you feed her that question?
I did not. No, that's a good question, though. I wish I had. My favorite part really is the clients. I was on, as Jennifer knows, and as Gary knows, and you may or may not know if you're watching, I've spent a large portion of my career on the defense side. And when you're doing that, you're often serving two masters. You're serving your individual defendant who has been sued, but you're also serving the insurance company. And quite frankly, I got tired of that, and I wanted to do a job where it was my client and me, and we were the ones that were deciding it. And so my favorite part has been able to do that and really help make a difference in people's lives. And I definitely think that my prior experience helps tremendously with that, because I know how the other side tends to look at things. I know how they tend to value things. I have a lot of experience with what they consider important and what they don't consider important, and all of that helps me better represent my clients.
Ken said, "Oh my God, I can't believe you remembered." Oh yeah, oh Ken, yeah, I remember. Are you kidding me? I mean, when you looked up at me and said they were cooking the books, it was amazing. And their cross-examination of you killed them, Ken. Ken is an interesting man. He worked as a corrections officer as part of the class, but then he's very smart. While he's working as a corrections officer, he taught himself how to be a computer programmer, and then they hired him and they brought him into the computer department. And then a major at, I think, SCC, I forget the prison, told him they were running data on this, and he told him to throw out the long shifts. Oh, I remember it like yesterday, Ken. So Ken, excuse me, I have another question. How many hours can you work legally? Arlene asks, how many hours can your job legally force you to work per week? Tyler?
Well, that's a good question, and that depends, I think, largely on how they're deciding to pay you or how they're deciding not to pay you. There are certain circumstances, under most circumstances, the standard is 40 hours, and above 40 hours, you get overtime. There are certain circumstances where, like salaried employees, Gary can crack the whip and have me work 110 hours. And,
I wish.
And as far as I know, there's not anything legally I can do to him about that.
You can quit.
I could, yeah.
But I wouldn't keep people around very long if I did that.
Yeah, it'd make it harder to keep employees. But a very big distinction in that situation is if you're considered a salary employee or if you're considered an hourly employee. But there's more gray area in the middle than I think that most people would expect.
There are federal and state laws that govern that. That it can depend on the circumstances. We take cases like that, and we're fighting cases like that now, and are proud to help people get paid. If you're an hourly employee under the law, the state has to pay you straight. Anybody has to pay you straight time for 40 or under hours and time and a half for overtime. Those are fights about that, and there's these fights. There's a lot of law, labor law. There's a lot of cases under labor law. Employers fight it, employees fight it. There's a lot of disputes, but you're entitled to that. You can make complaints to the Missouri Department of Labor, the Missouri Division of Labor, or the federal government's Department of Labor for violations of wage and hour laws. They have some enforcement mechanisms. There are also lawyers like us that do those cases, and other good lawyers who do. But good answer on our salary versus hourly. Is Missouri unusual for its lack of laws regarding breaks for workers? Maya asks. The answer is no, in my view, although there are certainly some states with more robust or protecting labor laws. You have seen an erosion of labor laws judicially and legislatively over the years. In the last 2 years, the state of Missouri got rid of its grievance procedure and civil service protection for its employees. It stopped withholding dues from all the state did as a leader. They're supposed to have the bully pulpit, and they refused to withhold dues from any of the state employee unions, causing them all to go out of business. They're refusing to renegotiate labor union contracts with these unions. There's lawsuits about that. And they're trying to destroy these labor unions and trying to destroy people's rights. So, it's not unusual. Wisconsin did that. Scott Walker did that in Wisconsin 5 years ago. So these traditionally Republican administrations, when they have both houses in the legislature to back them up, have been taking very strong anti-labor action. And if you're an employer in one of those states and the state government is doing that, I mean, do you think they're going to enforce it when you screw your workers over? No, they're not. Well, I got some more questions. Very cool turtle. Thank you, Diane. So this is a turtle. So I'm a big scuba diver. So this is a turtle that I bought one time. It's a sea turtle that I put out here. Thank you for noticing, Diane. I appreciate it. Here's a random question by Brennan. Is there anything that's absolutely not allowable in a court of law?
There's a lot that's not absolutely not allowable in a court of law. I mean, where do you want us to start? Really, the thing that I found in being a trial attorney is how much is up to the individual judge. And it really depends on the judge as to what's absolutely not allowable. And some of them have a very, very, very long list of things that are absolutely not allowable, and some of them have a somewhat shorter list. But I mean, like brandishing a firearm, I would not recommend in a court of law under any circumstances whatsoever. I would say that is absolutely not allowable in a court of law. I wouldn't.
There's a whole host of things. Just to echo what you're saying, there's a whole host of things. And that's why they have bailiffs in the courtroom to enforce the rules. And you can have people arrested. You can have lawyers arrested or held in contempt of court. I read an article about a judge who was just taken off the bench in another state because he grossly abused that power. There's rules for lawyers can get have ethics violations asserted against them or that kind of stuff. So you got to decorum, be on time, treat the court with respect. Don't interrupt the judge. Treat your opposing counsel with respect. I mean, it's an honorable profession. Being a lawyer is, and certainly we work to make it so. The other thing is in terms of what you can't not allowable in court. So there's entire rules about what can be said in a jury trial, about what you can tell the jury or you can't tell the jury. And if you violate those, you will get what's called a mistrial, and the judge will throw the whole case out. There are rules about what you're allowed to say, for instance, in closing argument. All the super effective arguments in closing argument aren't allowed in closing argument. So you can't do something called a per diem argument, where you can say, hey, if you pay my client, if my client's paying a separate is worth $50 a day, and he lives another 5,000 days, his damages are $2.5 million or whatever it is. You do the math. You're not allowed to do a per diem argument. You're not allowed to put your shoes in your client in the shoes of the juror. You can't say to the juror, assume you were my client and living with this leg off or this paralysis. How much money would you give him? So there's rules about not arguing an opening statement. There's all kinds of rules. And the lawyers, as lawyers, we need to memorize the rules. And when I go to trial, I re-hone my skills. I make myself read that to remind myself about what I can't say. So there's a lot of those rules that we abide by when we're in court. Anything else on that?
No, I definitely agree with lots of things that you're not allowed to say. And I find myself, when I'm in front of a jury, I often speak more slowly than I otherwise would, not only because I want to make sure that the jury is following me and that they can understand me and I'm not talking over myself, but also because I'm trying to keep those rules in my head and make sure if I phrase something that I phrase it the way I'm supposed to and not the way that the judge is going to tell me to bring my toothbrush because I'm being held in contempt overnight.
Yeah. I've never gotten close. However, even if you mess up, a judge is going to look out for you if you're doing it in good faith. That's why it's good to have a good rapport with the judge as well as a jury. All right, well, that's about all the time we have. We've been going for about 50 minutes here. Sorry, folks, for doing this in 2 stages. I had a hiccup on either my computer or my Wi-Fi. I'm not really sure. It said that I had to restart it, so we did. Thanks a lot for listening. This is Tyler. Thank you, Tyler, for doing this.
Thanks for having me.
I gave him no notice.
I got a little bit.
Yeah, it makes you a good lawyer. You got to get up and fly by the seat of your pants in it. And if anybody, we always answer questions for free. Email Tyler at tyler@burgerlaw.com. Email me, Gary@burgerlaw.com. We always answer people's questions for free and give out this kind of advice. We're happy to do it, or any other kind of advice. If you have any questions before next week, give us a call. If not, shoot us some questions in the comment section. Hopefully we'll do it in one fell swoop the next time. Thanks, everybody. Have a fantastic week.